This lecture would be devoted towards prevention of cruelty to animals Act 1960 and also relating to animal welfare. So the World Health Organization of Animal Health and the very five freedoms of declared would be discussed. First, the World Health Organization of Animal Health recognizes the following five freedoms for animals, such as freedom from hunger, thirst, and malnutrition, the freedom from distress, and the freedom from physical and thermal discomfort, freedom from pain, injury, and diseases, and accordingly the freedom from pain, injury, and diseases. So, according to the international guidelines, the Ministry of Environment and Forest of the Government of India established the National Institute of Animal Welfare, and the very act regarding to impact training and education in animal welfare and animal management, their behaviors and ethics. The institute works for better environment for animals and to fulfill the requirements as laid down in the Prevention of Cruelty to Animals Act 1960. The act cast on every person a duty to ensure well-being of animals. So, as per the provisions of this act, under section 3, which deals with infliction of pain and suffering, so as it provides that no infliction of pain or suffering on any animal. And in regard to that, we would like to discuss the important leading case relating to Animal Welfare Board A. Nagaraj in 2014 relating to Jallikattu and Bullock race as relating to Jallikattu and Bullock race, or they inflicting pain or suffering on bulls, and to prevent such practices under section 4 of the act we found relating to constitution of animal welfare board. Should the act under section 4 provides central government to establish animal welfare board for promotion of animal welfare by protecting animals subjected to unnecessary pain or suffering. And as well, section 11 provides the very definitions and forms of cruelty to animals. So it defines about cruelty to animals. So, these are being categorized in different forms, such as the first form of cruelty to animals relates to kick, bit, override, overdrive, or torture causing pain and suffering to such animal or animals. And the second form or category of cruelty is to employ any animal in any work if the animal is infirm or old age or suffering any disease. And the third category or form of cruelty is relating to administration of any drug or any substance to any animal willfully and unreasonably. The fourth category of cruelty is related to use any animal in any vehicle to carry load which causes pain and suffering. The fifth category of cruelty relates to keep or confine any animal in any case, denying reasonable opportunity of movement. And the sixth category of cruelty is to keep any animal chained for an unreasonable time. And the seventh or the last category of cruelty to animal is killing or mutilation of animals, including stray dogs, and keeping them under starvation, thirst, overcrowding, or ill treatment. And as while Section 14 of the Act provides regarding experiment on animals, who Section 14 of the Act forbids only certain kinds of experiment on animals for new discovery of physical knowledge or to combat any disease for alleviating suffering of such animals, while Section 15 of the Act provides regarding constitution of committee on experiment. So the Act empowered the central government to constitute a committee for the purpose of controlling and supervising experiments on animals to check unnecessary pain and suffering to such animals before, during, or after performance of such experimentation. And while Section 22 of the Act provides prohibition on exhibition of animals, so it prohibits on exhibition and training of performing animals. So animal rights become a subject matter of concern for many activities by fighting to save and sympathizing the cause of animals. We have seen that human beings owe a duty towards the animals, which ultimately is considered as a duty towards a society also. Duties towards animals did not correspond to private rights vested with them, but to public rights vested in the community at large. The matter on animal rights was raised in that important leading case, Animal Welfare Board of India versus A. Nagaraj in 2004, in which the question of validity of Jallikattu of Tamil Nadu and Bullock race of Maharashtra were questioned. The apex court denied the constitutionality of such existing legal provisions, following such practices in the name of culture, tradition, religion, etc. Accordingly, the apex court, the Supreme Court, took strong views that these practices are violative of animals' rights and the restrictions imposed by the central government was held valid. Further, the apex court expresses that bulls cannot be used as farming animals, so the provisions of the Prevention of Cruelty to Animals Act 1960 was declared valid, and any action under the Act by the governments are justified to save animals' rights from inflicting pain, injury, and suffering. But as per the recent decision of the Supreme Court, which has upheld amendments made by Tamil Nadu Karnataka and Maharashtra to the Prevention of Cruelty to Animals Act 1960 to allow the traditional bull taming sports of Jallikattu and Kambala in Karnataka and Bullock cat racing in Maharashtra. So the cases involves a challenge to the Tamil Nadu amendment allowing Jallikattu based on the argument that it goes against the central law prohibiting cruelty to animals. So the very judgment relating to this is relating to Animal Welfare Board of India versus Inagras, which we have discussed. It was a ruling of 2014 which prohibited Jallikattu, also block race in Maharashtra. And the amendment laws, those we have to discuss, met with the government of Tamil Nadu, Maharashtra, and Karnataka. So, the Supreme Court ultimately held the state amendments such as the Prevention of Cruelty to Animals Tamil Nadu Amendment Act of 2017 and also the Prevention of Cruelty to Animals Conduct of Jallikattu Rules of 2017. So, as per the decision of the Supreme Court, it did not violate the Constitution and also the Supreme Court's 2014 ruling banning Jallikattu. So the court and the Amendment Act substantially reduced pain and cruelty to the participating animals. The judgment holds that the 2017 Amendment Act and rules on Jallikattu are in time with entry 17 Prevention of Cruelty to Animals of the concurrent list and Article 51A Clause G Compassion to living creatures of the Constitution. So the Supreme Court banned Jallikattu through a judgment in May 2014 in the Animal Welfare Board of India versus Inagra's case on the grounds of cruelty to animals. The court said that the act was not relatable to Article 48 of the Constitution, which deals with the duty of the state to organize agriculture and animal husbandry. It also stated that any violation of the law in the name of cultural tradition would be punishable. The court decided that determining Jallikattu's cultural heritage status is the best left to the state's legislative assembly and not a court of law. So, exactly in that particular decision and where Supreme Court held the validity of Jallikattu, Bullock cat race and Kambala in Karnataka, and that is the most landmark judgment relating to Prevention of Cruelty to Animals Act 1960 is the Animal Welfare Board of India and others versus Union of India and another in 2023. So now we would like to discuss what is Jallikattu. Jallikattu is a traditional sport that is popular in Tamil Nadu. The sport involves releasing a wild bull into a crowd of people, and the participants attempt to grab the bull's hump and ride it for as long as possible or attempt to bring it under control. It is celebrated in the month of January during the Tamil harvest festival, and that is Pongal. So, the arguments in favor of the practice before the apex court is that Jallikattu is considered both a religious and cultural event in Tamil Nadu celebrated by people regardless of their caste or creed. The state government argues that instead of completely banning this century old practice, it can be regulated and reformed as society progresses. They believe that prohibiting Jallikattu would be seen as an attack on the culture and sentiments of the community. The government asserts that Jallikattu plays a role in conserving a valuable indigenous breed of livestock and that the event itself does not go against principles of compassion and humanity. They emphasize that the significance of Jallikattu is being taught in high school curricula to ensure its preservation for future generation, and those arguments in opposition to Jallikattu and Bullock race are. It is argued that all living beings, including animals, possess inherent liberty as recognized by the Constitution. Jallikattu has resulted in deaths and injuries of both humans and bulls in various districts of the state of Tamil Nadu. It has been observed that farmers act aggressively towards the bull, causing them extreme cruelty. Critics compared Jallikattu to practices like sati and dowry, which were once considered part of culture but were abolished through legislation. And as regarding Kambala, which is a practice in Karnataka, it is a traditional buffalo race in paddy fields filled with sloth and mud, which generally takes place in coastal Karnataka, in particularly Udupi and Dakhin Kannada from November to March. So, the very provisions of the Act, that is Prevention of Cruelty Animals Act 1960, as we have discussed in relating to the famous judgment that was the Animal Welfare Board versus A. Nagras in 2014, where the apex court denied any such organization of events such as the Jallikattu in Tamil Nadu and Bullock race in Maharashtra. And after that, we have discussed certain important provisions of the Act Prevention of Cruelty to Animals Act 1960 in relation to the very prohibition regarding infliction of pain and suffering as per the provisions under Section 3 of the Act, then the constitution and establishment of the Animal Welfare Board by the central government as per the provisions of Section 4, and then what exactly cruelty means and what are the different forms of cruelty met to the animals as provided under Section 11. Then we have discussed regarding experiment made on animals for certain scientific and medicinal purpose, and that we have discussed as per the provisions of Section 15. And besides that, the committee which would be constituted by the central government for making its observation and recommendations on such experiments on animals as provided under Section 15 of the Act. And finally, We have discussed regarding section 22, which prohibits an exhibition of animals, and also regarding exhibition of any performance by any performing animals. And finally, we have discussed the very animal rights and the opinion of the apex court or Supreme Court. So first we have discussed the most important leading case, Animal Welfare Board of India versus Inagras in 2014, where Supreme Court outrightly rejected of such practices of Jallikattu and Bullock either in Tamil Nadu or Maharashtra. And finally, the state of Tamil Nadu brought amendment to the Act as Prevention of Cruelty to Animals, Tamil Nadu Amendment Act 2017, and also those rules relating to prevention of cruelty to animals, conduct of Jallikattu Rules 2017, and as at the Tamil Harvesting Festival of Pongal, where such practice is continuing, and after that Supreme Court upheld the amendments to the Prevention of Cruelty to Animals Act 1960 by the Tamil Nadu government and allowed the performance of Jallikattu, Bullock race of Maharashtra, and also in that particular important leading case in 2023 as Animal Welfare Board of India and others versus Union of India and another. And also we have discussed exactly what Kambala means in Karnataka, and as it is a traditional buffalo race in paddy fields with slosh and mud, which generally takes place in coastal Karnataka, in particularly the districts of Udupi and Dakhin Kannada, from November to March. So also we have discussed certain provisions of the Constitution as made observation made by the apex court while discussing the very provisions of the Prevention of Cruelty to Animals Act 1960 and in relation to the amendments made to the Act by the Tamil Nadu state in 2017 and those rules of 2017, in particularly the provisions relating to directive principle of state policy, in particularly Article 48 of the Constitution and also Article 51A clause of the Constitution relating to the very provisions of Prevention of Cruelty to Animals Act 1960 and in regards to animal welfare.